Hello, everyone. Welcome to Q&A Disability Law. My name is Sivan Tumarkin. I'm a disability lawyer, personal injury and disability lawyer. I work in Ontario, in British Columbia, in Alberta, really throughout the country, throughout Canada, with the exception of Quebec. We help people who have issues with their disability claims, long-term disability claims. We answer questions, we inform, we advise. And so this is an opportunity for you right now to ask any questions you may have about your claim or a friend's claim, a family member's claim, and I'll do my best to answer. Let me start off with a particular issue that comes up quite frequently, and that is when somebody is actually receiving long-term disability payments from their insurance company, and they receive it up until about the 1 year, 1.5 year mark, and then they get a letter from the insurance company or an email that says, we don't believe that you will qualify for long-term disability payments beyond the 2 year mark. They always mention that 2 year mark, that change of definition date. And the reason why that's important, why you need to be aware of it, is because under most long-term disability policies out there, to qualify for long-term disability, and this is through usually insurance that you have through health benefits, through work, or if you have a private policy, typically there is a provision in there that states that for the first 2 years, to qualify for long-term disability, you have to demonstrate with the help of your doctors that you're unable to perform the essential tasks of your own occupation. Your own occupation. That's absolutely key here, your own. The 2 year mark is where the qualification changes, the test changes. Now, the test is no longer can you perform the essential tasks of your own occupation, but rather can you perform the essential tasks of any occupation for which you're suited for by training, education, or experience. And this is where most people hit a brick wall with the insurance company, where the insurance company says, we believe that you, John or Jane, are able to do some other work. We believe that you can go out there and with your skill set or your experience or your education, you can do some other job. And by the way, here's a list of jobs we think you can do. And in many instances, people are unable to do that, but they don't know what to do because the insurance company said that they're going to cut them off. They're going to stop the benefits coming in. And so I typically tell people, look, if your doctors tell you, and if they've written down on paper, in a note, in a report to the insurance company, that you continue to be disabled, that you're unable to work in any capacity, then you should continue getting LTD, those payments beyond that 2 year mark. That's really, really important to understand. When the insurance company tells you they're going to cut off your benefits, that's not the end of the world. Don't panic. Absolutely don't panic. And people call me because they are in a panic. And of course, the letter from the insurance company typically says, well, you can appeal this decision. There's always that option that the insurance company gives you to appeal. And people ask me, should I appeal that? Should I go to my doctor or doctors or different doctors and trying to get something there that potentially helps me with my case, convince the insurance company that they made a mistake, that really I'm unable to work? And I tell them, look, you can try to do that. The reality is that you're appealing to the exact same people, the same company. They cut you off, in the first place. So it's really, really important to understand that there is a much stronger tool there, and that tool is the legal tool. It's a legal claim against the insurance company. It's us telling the insurance company that if they don't continue payments, they're going to face a legal claim. And I'm telling you, as somebody who used to work for insurance companies in the past, they don't like getting that, because when they get that, all they think in their mind is, now we're going to have to hire our own defense lawyers, and that's going to cost us money. And I always joke, and it's true, that the one thing insurance companies hate more than paying you what you're owed is paying their lawyers to fight a claim that they know they're going to lose, because they're going to have to pay you at the end. I'm just going to break here for a second. We have a question here from Ibronte. What about getting LTD for fibro? I assume that's fibromyalgia. How successful do you find those claims are? Excellent question. Fibromyalgia is a condition. It's a very painful condition. There's a lot of controversy with that, and that some doctors believe it, some doctors don't. I am telling you 100% it exists. I know people who have fibromyalgia, and I can tell you it can be absolutely debilitating. To your question, if you have a doctor or treatment providers who say that because of your condition, fibromyalgia, you cannot perform the tasks of your employment, you simply can't, you should be getting LTD. And if the insurance company denies your claim, we can step in and we can help you. But fibromyalgia is one of those types of claims, types of illnesses, like chronic pain. If you think about it, that's what it is. where insurance companies often treat that as a second-class illness. And they say, well, we don't believe that. We don't think that's true. We can't find any objective evidence. Nonsense. Absolutely nonsense. If you have a doctor, treatment providers who confirm that you have this, who confirm that you are disabled because of this, you should be getting LTD. Next question I have here. The question on YouTube from John C. My insurer wants me to apply for CPP disability benefits, but I don't think I want to do that. Can they force me to apply for them? Will I be cut off if I don't? Fantastic question. And it's a fantastic question for various reasons. First answer, can they cut you off LTD if you do not do what they tell you, which is apply for CPP disability? Keep in mind, CPP disability is government disability, federal government disability, whereas LTD comes from an insurance company. First, ask yourself, why does the insurance company want you to apply for CPP disability? They want you to apply because if you're accepted and you receive CPP disability, you don't get that on top of your LTD. Okay, you're still getting the same amount, except that the insurance company typically gets a credit for whatever you get from CPP disability. So of course you're saying, well, I don't want to apply for it. Here's the problem if you don't apply for it. The insurance company may argue that you have an obligation under your policy to apply. And if you don't apply, they'll guesstimate how much you're supposed to be getting and then reduce your LTD benefits accordingly, month by month. I tell people, look, you should apply for CPP disability if you're disabled. There are more upsides than downside. One of the upsides are that if you get accepted for CPP disability, it'll make it that much more difficult for the insurance company to cut you off later if they try to argue that you're not disabled, because the government has deemed you disabled for CPP disability. Secondly, if they do cut you off, and then we fight them on that, while we fight them on that, you're still getting paid by CPP disability, by the government. So you're not going to have a period of time where you have no money coming in. So there are many advantages to applying for CPP disability. Again, your choice if you want to do it or not. But if you don't, no, the insurance company should not be able to cut off your LTD, but they may tell you that they will guesstimate what they think you are entitled to and then reduce your benefits. There's controversy as to whether or not they're allowed to do that. So just, be aware of that. But again, I tell people, give me a call. It doesn't cost anything, by the way, to speak with me, a member of my team, about any of these questions. If you have questions after the live stream or at any point. Next question here. This question is from Brianne, YouTube as well. If you are injured at work and become disabled as a result, does the employer have any obligation to help with your disability claim or provide compensation? Excellent question as well. If you are injured at work, your claim may be covered by workers' compensation. Different provinces have different schemes. For example, Ontario has WSIB. British Columbia, Alberta, they have WCB, but they're essentially the same idea, which is it is a compensation scheme that is quasi-governmental, not the most favorable for employees, unfortunately, but it's not the employer that pays, it's that government disability program that is going to be paying here. But does the employer have any obligation to help with your disability claim? Well, if you have LTD coverage through work, through your work benefits, or short-term disability for that matter, you need to see if you can apply for those. You won't be able to get money from them and from workers' compensation at the same time, because you can't get one on top of the other. Typically, there is a credit that the insurance company gets if you're entitled to workers' compensation. But you should be getting something. And if you're denied workers' compensation, you should be able to apply and get short-term or long-term disability benefits. And again, if you don't, well, by all means, please give me a call and we're going to help you. Questions coming in. I'm trying to answer them as fast as they come. From Reddit, from / do I need to see the insurance company's doctor in order to have my claim approved? Very, very common question. No, the answer is no. If your doctors, if your treatment providers fill in the application and help you out with your application for disability, and they confirm that you are disabled, that because of your illness or injury or whatever the situation is, if you are unable to perform the tasks of your employment, you should qualify for long-term disability. However, in many cases, the insurance company will say, we want you to be seen by one of our doctors. There is a term for this. The term for this is independent medical examination. I'm smiling because it's laughable. Why is it laughable? Because the term independent is anything but that when it comes to these examinations. The insurance company is the one that's selecting the doctor for a reason. The insurance company is the one instructing the doctor. The insurance company is the one paying the doctor. So think about this. What do you think the doctor is ultimately going to do? Well, in many, many cases, the doctor cranks out a report after assessing you that is favorable to the insurance company. But again, you don't need to panic. This is very, very common. Unfortunately, it's very common. And the way you deal with this is you get your doctors on board, because your doctors, remember, they're the ones treating you, whereas the insurance doctor is a hired gun. And if it came down to credibility between the insurance doctor and your own doctors, I can tell you that if it went to court, not that these things go to court often, they very rarely go to court. Insurance companies hate taking these cases to court because they lose. But a judge would most likely side, in most cases, with the treating doctors. So I would not be concerned about the insurance doctor. But to answer the question again, as long as your doctors are saying that you are disabled, you should be able to get long-term disability. And if there's any problem with that, again, you reach out to me and we'll deal with your situation. From Mendel 12. My mom is being asked to attend a discovery, I think, for her LTD case. She suffered a traumatic experience on the job. What should she expect during this? That's a complicated question. It's complicated because I need to understand a bit more about what's happening here. A discovery is typically when we look at American TV, American shows, you hear the word deposition. This is when the lawyer for one side gets to ask questions of the individual on the other side. That's what a discovery is. It's when the lawyer for the insurance company gets to ask your mom questions about what's happened, what she's experiencing, etc. She should expect that there's going to be a lot of questions about her medical history. She should expect that there's going to be a lot of inquiries, and they're going to be asking for medical documentation, etc., to be produced. It's not abnormal to have these. This is part of the process. It doesn't happen in every case to have a discovery. In many cases, it's unnecessary. I assume if she's having a discovery here, then she has a lawyer. So the lawyer should be able to really prepare her properly and to make sure that he explains or she explains everything to your mom. And that's something that I want to put out there for a second, which is in many cases, people come to me and they have representation already. They have a lawyer. And I don't like to obviously give advice if there's another lawyer present. I don't think it's fair for that lawyer. That said, in many cases, people come to me and say, look, I've spoken to my lawyer. I'm not getting answers, or the lawyer is being unresponsive. And I just don't know what to do. And of course, the anxiety builds up and it creates, a really bad situation. Your lawyer has a duty to you. Your lawyer is there to protect you, to go after the insurance company. Your lawyer must prepare you and answer all your questions. Your lawyer must be responsive to you. That is actually a pet peeve of mine. I always tell people, look, if you email me at 5 a.m., you'll get a response most likely at 5:01. I'm not saying everyone should be like that, but I do get very upset when I hear that lawyers take their time and you have to follow up with them over and over. Certainly lawyers in my firm are not allowed to do that. So in this case here, with respect to the question about discovery, if your mom has a lawyer, please make sure that that lawyer responds, that the lawyer explains everything. This is not difficult for the lawyer to do. And if there is an issue, again, a question, the lawyer can't explain for whatever reason, or there's a problem with the lawyer, I'll be more than happy to speak with her, but try with the lawyer first. Another question from Mendel 12. Are there any topics that are too traumatic that you have to discuss them? So here's the deal. This is in respect of the discovery that was just asked. If your mom is, if the legal claim is with respect to a certain type of injury or illness or experience, if that is the thrust of her claim, well, then the other side is allowed to ask questions about them. The test as to whether or not they're allowed to ask a question is relevance. Is there a semblance of relevance? That's the key term, the legal term. Is there a semblance of relevance to the question that is being asked? And if the question that's being asked or the documents are being requested are relevant to the issues that were raised by your mom in the case, then yes, she's going to have to answer. And if she doesn't, that's going to be a problem. But again, that's something that her lawyer should be able to explain. Kwasi Yaboa. Do you deal with Manitoba public insurance? We deal with insurance companies across the country with the exception of Quebec and some of the territories. So Manitoba, Saskatchewan, of course, Alberta, British Columbia, the East Coast, the West Coast, we deal really with all of them. In some instances, we are precluded from being able to help. I'm not going to get into this, it's technical, but generally speaking, when it comes to long-term disability, we can pretty much advise you across the country. and represent you across the country. That's not an issue. Do insurance companies look at my bank's purchase history? That's from Jason J. That's an interesting question. If this is in the context of long-term disability, I'm not sure why they would need a purchase history. Again, they need to be able to justify the request. If you are pursuing a claim for long-term disability because of an illness or an injury, what does your bank's purchase history have to do with that? I understand why they would ask questions about your job, about whether or not you have a business on the side, things like that. But bank's purchase history, I would block that request. I don't really understand what is the relevance of that request from the insurance company. Again, remember, the insurance company can only request information and documentation relevant to the issue that they're dealing with. And if the issue is your health, your mental health, your physical health, your job, then they're going to ask some questions. By the way, it's not an open door policy when it comes to those topics either, right? This is one of the things that I tell people is you have to make sure that when you're dealing with the insurance company, that you understand that they're professionals. The adjusters you're dealing with, the people you're dealing with there, even though they're supposed to be your insurance company, they're supposed to be your safety net, they are adverse in interest to you. They don't want to pay you. They don't. It's kind of a crappy situation, right? I mean, they get premiums paid to them. We all pay premiums for house insurance, car insurance, travel insurance, health insurance. Maybe your employer paid for that. And yet when it comes time to pay, they try to find every excuse in the book not to pay. So you have to understand that their job is to try to not pay. And so when they're asking for information or documentation, they're doing that for a purpose. They're trying to figure out if there's anything in there that they can use against you, right? What do they say on cop shows, whatever you say can and will be used against you. Insurance companies will do the same thing. Some things, though, have to be disclosed to them. Some things do not. So it's a good question to always verify with a lawyer, with someone like myself, whether or not this is something that you should be providing. And I'll say this about that. Sometimes you get approved for long-term disability, and the insurance company will say, we require more documentation, or we don't believe this doctor or that doctor. It's really, really important to understand that the insurance company is not, they're not the final say. They're not the judge. Sometimes they will say things or ask for things that they're not permitted to do. Maybe the adjuster is not aware that they're not permitted to do it, but don't assume that whatever they tell you is always accurate and correct. I'm not saying that they intentionally mislead you. What I'm telling you is that they're human beings over there. They're not lawyers, the adjusters, and their job is not to protect you. Their job is to protect their overlords, the insurance company. Okay. Is diabetes a disability? It can be, certainly. Diabetes can progress to a point where you need an amputation, for example, right? If it's extreme. Diabetes, any condition, think about it this way. Any condition that manifests in symptoms, either psychologically or physically, or both, that prevents you from being able to do your job, your occupation, can be the basis for a long-term disability claim. If you have doctors or treatment providers, people who are treating you, who are telling you that, yeah, you should not be working right now, you should be getting treatments. So whether that's diabetes, whether that's anxiety or depression or back pain or a neurological disorder, whatever the situation is, if you have an illness or an injury, or a combination of both, that prevents you from performing the essential tasks of your job, you should qualify for long-term disability with your insurance company. And if there is any problem with that, if at any point they say no, you have to reach out to me as soon as you can, because we'll be able to look, me and my team will be able to look at the documents and tell you over the phone really quickly. Again, this doesn't cost anything, just like this live stream, but we'll be able to tell you what your options are, and then you can decide what you want to do. Nikia Roberts, can my employer put blame on the third-party accommodation provider for their suggestion? Should I be a part of the process aside from the initial documents that was requested? So we're dealing here, I think, with a quasi-employment matter, and of course, many of the lawyers in my firm do employment law, but there is that intersection between employment and disability, right? The person has issues, whether, again, it's an injury or an illness, and maybe it's not an issue with your insurance company not approving you, but maybe the employer is the one that's not playing ball. Can your employer put blame on the third party? They could, sure. You should be part of the discussion. Your doctor should be part of the discussion. Your doctor should be the one saying, here's what you are able to do, or what the doctor believes should be the accommodations for you to be able to do whatever part of your job the doctor feels you can do. And if the employer doesn't acquiesce, the employer can use a third party, but ultimately there is a duty to accommodate. There is a legal duty to accommodate. It's called duty to accommodate. You can Google that. It's in Canadian law, it's enshrined, and it's in pretty much every jurisdiction in the country. And if the employer doesn't do what they're supposed to do, well, then there is a potential claim against the employer. If you're a unionized employee, well, your union should be able to step in. If not, and there is a problem here, again, this is something where we may be able to assist you. Not me, I'm not an employment lawyer, but there are lawyers in my firm that can definitely help. Another question from Jason J. Would it hurt my LTD claim if I go on vacation to Europe for a month? Excellent question. First thing I'll tell you, Jason, is there are several answers. Number one, look at your LTD policy because it may contain a provision that talks to being out of the country, whether it's for vacation or other reasons, okay? You may have a provision in there, because they do exist, not in every policy, but in some policies, where it says that if you're out of the country, during that period of time when you're out of the country, you may not qualify to receive LTD benefits. So really important to understand that you want to be aware of what your policy says. Let's say your policy doesn't say that. Let's say it doesn't speak to vacation. You still need to be careful. Why? Let's say that you go on vacation. Let's say the insurance company finds out. Maybe they see your social media posts. Maybe they ask you a question and you're being honest. Maybe they look at your doctor's records and it says that you've been on vacation. You can see a situation where an insurance company would simply say, look, if you're good enough to go on vacation, maybe you're good enough to work. Again, I think that's a ridiculous conclusion to draw. You may be suffering from depression. Maybe this is a good thing for you. Your doctor even says, go somewhere, and relax, or maybe you need treatments in a different country. And that's like a vacation. But my point is, first, you look at your policy to see if your policy prohibits you from actually leaving the country, or if you're not going to get paid during that period of time. Second issue is, if you do go on vacation, can the insurance company cut you off or deny your benefits? They could. Doesn't mean that they have a right to. I've had cases where they've done that, only for me to come back and say, well, it doesn't say in the policy the person can't go. There's no prohibition on that. The doctor actually believes it's going to do good for them. So explain to me why it is that you've cut off their benefits. And so I've had them reinstated on benefits, or I've had a resolution reached with the insurance company. So insurance companies, by the way, on this point, they can stop your benefits for virtually every reason, any reason. I'm not saying that you can't challenge them, right? But if they don't like the color of your shirt, they can say, we're going to cut off your benefits. Well, that's going to be a problem for them, because we're going to go after them and they're going to have to pay you. My point to you is that the fact that they've cut off your benefits, or that they're telling you they're going to cut off your benefits for any number of reasons, doesn't mean that those reasons are legit. Doesn't mean we can't challenge them. That's why I tell people, if the insurance company tells you your benefits will stop, don't take that at face value. Come to us, speak with us, so we can tell you, is this real? Is it not? Do you have a leg to stand on to challenge that denial? Can we help you, etc.? And at least at that point, you will know what your options are. Okay. Sorry, I'm going back here on a question. I don't have a lawyer. I'm wondering why the federal government cut me off 4 years ago. I don't know why they cut you off, JP Wilson. The problem is that if it was 4 years ago, and this is important to understand, this is a good point you've raised, there's a limitation period across most jurisdictions in the country, a 2-year limitation period. If your first denial, I say first denial because sometimes people appeal these denials. If your first denial happened more than 2 years ago, you may be out of time to start the legal process to force the insurance company to pay you. So you have a 2-year limitation period. There are some exceptions. You don't want to fight those exceptions, okay, because it's an uphill battle. But always remember, if you are told that you are denied a claim, or if you are told you will be denied a claim, meaning your own LTD, and they tell you in a month or 2 months or 5 months we're going to stop benefits, seek legal advice now. Talk to us right now. Don't wait. Exactly for this reason, with this gentleman here, where he was cut off 4 years ago. Even if I thought there was a way to challenge that denial, it's 4 years later. I can't do anything, unfortunately. S. Barton, why would an insurer deny an LTD claim if you have already been off on STD? Fantastic question. Fantastic question, because if you remain disabled, they shouldn't. You should be qualifying for LTD. Think about this. If you're off on short-term disability, the test for short-term disability and the first 2 years of long-term disability typically are the same. Can you perform the essential tasks of your occupation, of your own occupation? Are you disabled? And if you remain disabled and your doctors say that you remain disabled, you should qualify for LTD. You should not be cut off or denied LTD. Those kinds of claims are actually fairly, not easy, but they're easier to deal with. Now, sometimes the STD insurer is different than the LTD insurer. Doesn't matter, irrelevant. The point is, if you qualified for short-term disability and then you try to transition and you got denied at that transition stage into LTD, we should be able to help you, so long as your doctors are telling you and they've written that you're still disabled. We should be able to help you get those LTD benefits. BC Pinoy. I am on LTD claim right now. My insurance keeps sending me to 3 different occupational therapy and rehabilitation, but my doctor said he's the one that's going to send me once I'm ready. Who am I going to follow? Excellent question. I always tell people on this point 2 things to keep in mind. Number 1, go to whoever your doctor recommends. Why? Because I'm always suspicious of the people that the insurance company wants to send you to. I'm not saying they're bad or they don't know what they're doing, but you got to think, why are they sending you to that particular clinic? Maybe it's because that clinic gets a lot of business, and that clinic, after a few treatments, tells the insurance company that you're good to go back to work. I'm not saying it's going to happen. I'm just saying, think about this in those terms. Whereas your family doctor is looking out for your best interest. Now, you need to look at your LTD policy. Does your LTD policy require you to go to whoever the insurance company sends you to? If it requires you, well, then you have to go to them, because that's what the policy says. That's an obligation. It's a contractual obligation. But typically, insurance policies do not have that. Typically, what these policies say is they say that your obligation is to get reasonable treatments. Well, it's certainly reasonable in my mind for you to go to whoever your family doctor recommends you to go to. And so if I had a choice between going to whoever the insurance company recommends or whoever my family doctor recommends, hands down, I'm going to whoever my family doctor recommends, because my family doctor is looking out for me. The insurance company is looking out for them. Again, I tell people, if you have any issue with this, you get pushback, contact me directly, and we'll be able to advise you about your specific situation here. JP Wilson, I'm on type 2 diabetes, insulin. I'm aware of that. Again, if your diabetes prevents you from working, and I know we talked about the fact that this was a few years back, but any type of condition that you have, if you're unable to work because of it, you should be able to get LTD if you have coverage for it. And if that does not materialize, if the insurance company denies you, you need to reach out to us so that we can talk to you and actually speak with you about your specific situation and tell you what your options are. From MSZ Butterfly, that's the name here. Currently on STD, shortened disability, because of no to limited accommodations as per my doctor's suggestions. They're now delaying my return to work. Reason: limited evidence to support claim. I have 2 invisible disabilities. Whoa, okay. So first of all, again, on the employment front, employers have a duty to accommodate. So if your employer is not accommodating you and you're not unionized, reach out to me directly. I'll put you in touch with one of our employment lawyers who will advise you. Okay, really important. But your question here is, you're saying that your insurance company, they're saying limited evidence to support your claim. You have 2 invisible disabilities. The word invisible, I actually just dealt with that yesterday. There's no such thing as invisible disabilities. When people talk about that in the context of insurance, it's when insurance companies are saying there's nothing objective. We can't see, you can't see anxiety or depression on an MRI. You can't. Sometimes you have back pain or a headache. You can't see that on a CT scan necessarily. And so that's an invisible disability or invisible illness, let's say, or whatever it is that they want to call it. It doesn't matter. Invisible, visible, whether you can see a broken arm or not, irrelevant. If you have doctors on your side, they're saying you're disabled because of so-and-so, the insurance company should approve your short-term and or long-term disability, whatever you're applying for. If they're not, this is when we need to challenge them. Because as long as your doctors are confirming that you cannot work at the present time, the insurance company should not be able to deny your benefits. They'll try, because they know that when they deny these benefits, the majority of people just walk away, or they appeal those decisions and then they get denied again and again. And at some point they shake them off claim, right? People give up. Don't give up. This is why I say to people, look, get empowered, get this information, reach out to us. Doesn't cost anything to speak to me, member of my team, but don't let the insurance company just, get away with it and keep the money that's rightfully owed to you. Question from Paul on Facebook. Are you able to help with disability claims for union employees? Yes. In the majority of cases, yes. Not always. We have to look at the collective agreement. It's an analysis we have to do, but we do help quite a few employees who are unionized with their long-term disability claims. In fact, sometimes the unions tell people, you got to get a disability lawyer to help you. So again, the answer is yes in many, many instances, but we have to look at your specific situation, look at the collective agreement, what it says, and then we can tell you if we can help or not. And if we can't, we'll tell you what we think you should do. So at the very least, you'll get something out of it. But if we can help you, which we can most of the time, then that would be fantastic. I think we are out of time, and those are the questions. I hope you enjoyed today's session. Please follow us and take a look at the future live streams. We do a lot of them on disability law, on employment law. And if you have any questions after this session, feel free to reach out to me directly. The next session that we have here is with an employment lawyer at my firm, an excellent lawyer who will tell you a lot about employment law rights, your rights as an employee. Jeremy Herman. It's on Thursday, February 6th at 2 p.m. Eastern Time. Looking forward to seeing you again, and thank you for joining.